Generally, unless the employment contract allows the employer to make changes, the employer will need to get the employee's agreement to vary the contract. If the contract permits the changes, no variation will be required. An employer may be able to rely on a specific flexibility clause to make the changes. Examples could include mobility clauses, allowing an employer to change the employee's place of work, or a clause allowing the employer to change the employee's duties. However, the courts have tended to interpret flexibility clauses narrowly, and care needs to be taken when drafting such clauses. It's quite common for employers to include a clause at the end of the contract that states that employers have a general right to make changes to the contract. However, employers would have considerable difficulty in relying on these clauses to the detriment of the employee. The clause would usually only allow the employer to make minor administrative changes. If the contract does not permit the change, the employer will need to obtain the employee's agreement, preferably in writing. In England and Wales, there needs to be consideration for a contract, though there is no requirement for this under Scots law. That means that if the employer wishes to make a change to the employee's detriment, the employer would have to offer something positive in return. When an employer cannot get the employee's agreement, there is another option. Providing the employer can demonstrate a sound business reason for the change, carries out consultation as required, warns that any continued refusal could result in the employment being terminated, and offers re-engagement on the new terms, a subsequent dismissal could be fair. For more information, do visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.